Well, thank you all for joining us this morning. We are really excited to be hosting this in partnership with the Vermont Law and Graduate School. This is the Intellectual Property Basics webinar. We are going to keep the recording on throughout so that those that are unable to join are able to view it in the future. We ask you to mute yourself when you're not speaking and to throw questions into the chat. Alternatively, if we come to a question break, you may unmute yourself and ask them then as well. Simeon and I will make sure that they get attended to. After the workshop, I'll make sure that you receive all the contact information for our programs, as well as links to any resources that we go over, and a copy of this presentation and these introductory slides. So without further ado, I will pass it over to my colleague, Simeon Geigel. Thank you, Simeon.
Thank you, Sophia.
Oops. Let's see.
Good morning, everyone. Thanks so much for joining us today for this topic. I'm really pleased that we can offer this and to welcome Brian Bailey from the Vermont Law Center. And I just like to do a quick introduction to our program, the Micro Business Development Program. It is a statewide program that works with low to moderate income Vermonters to help them start or expand a business. So we provide business counseling. And there's no fee for our services, which mainly is one-on-one business help, but we also offer classes like this throughout the year as well. To learn if you qualify, you are welcome to contact either myself or John Gergley. Both of our contact informations are at the bottom of the screen here. And if you're interested in connecting with us, we'll also be connecting you with Sophia as part of that process as well. But just to remind you, the Micro Business Development Program is a statewide program, and our office covers the northwest corner of Vermont, which includes Chittenden, Franklin, Grand Isle, and Addison counties. Next slide, Sophia. Sophia, do we have the other one with the other micro businesses that cover the area?
Yes, I think that one comes up a couple slides after.
Oh, gotcha. Okay, thanks. So we would like just to do a quick shout out to some of our partners here, which includes the People's Trust Company. People's Trust Company offers a variety of commercial and banking products and services, as well as business consulting services to help their clients succeed. The contact for People's Trust, which is up in St. Albans, is Jay Cummings. Jay also does a lot of different webinars as well on different business topics. So if you don't really need to connect with People's Trust for yourself personally, it is still worth connecting with them to have access to their ongoing webinars. Thanks. I'd also like to thank Lake Champlain Economic Development Corporation, Franklin County Industrial Development Corporation, the Addison Economic Development Corporation, and GBIC, the Greater Burlington Industrial Corporation as well. We appreciate the work that they do and helping to promote our classes. As I mentioned earlier, microbusiness is a statewide program. There are other micro businesses that cover other counties in the state. Down in the Bennington-Rutland area, we've got Brock. Capstone Community Action covers Washington County, Lamoille, East, and West Orange. Mentioned CVOEO already, but that's Addison, Chittenden, Franklin, and Grand Isle. NECA covers the Northeast Kingdom, including Caledonia, Essex, and Orleans counties. And finally, back down towards the southern end of the state, we've got Windham and Windsor counties. So if you live in one of those one of those regions, and in one of those counties that that micro business covers, don't hesitate to reach out to the counselors there. There's also our main micro business development program website, mbdp.org, and you can make these same connections on that website as well. Next. Finally, just like to mention that there are other support services I encourage everyone that I work with to uh, be aware of and to tap into their strengths. We've got the Burlington Business and Workforce Development Department, Center for Women in Enterprise, the Mercy Connections Women Small Business Program, the Vermont Small Business Development Center, also known as the SBDC, Small Business Administration, SBA, and finally Champlain Valley SCORE, which I think has just changed its name to SCORE Vermont and New Hampshire. So they've just consolidated regionally. Next.
That's all for our introductory slides.
Great. Thank you,
Um,
Sophia. So once again, I'd just like to introduce Brian Bailey from the Vermont Law Center. Thanks, Brian, for coming today to cover this really important and interesting topic. I know that we have a lot of folks who are artists or crafters, designers, creators that often have questions about this topic from a lot of different angles. So look forward to learning more, and I will pass it off to you.
Great. Thanks, Simeon and Sophia. Hello, everybody. Thanks for the introduction. So, yeah, I am Brian Bailey. I am a staff attorney with the Vermont Small Business Law Center, hosted by and resident in the Vermont Law and Graduate School. Unlike my fellow professors at the school, I'm also a private practitioner, so I both teach and have a law practice in Montpelier. So I've been doing this for about 20 years. I've spent most of my career as an intellectual property attorney in a big law firm. Prior to that, I was a mechanical engineer and trained that way. So, the intersection of technology and law is what I do. So, we're going to talk today about intellectual property, and I'm going to share my screen so you've got something to look at other than me. So I already said sort of who I am and why I'm here. My colleague Oliver Goodenough could not make it today, so you're stuck with me. But I think we'll be able to give you plenty of good information. So what are we going to do today? We're talking about intellectual property. We're going to have an overview of sort of what that means. What is intellectual property, sometimes referred to as IP? And then we're going to talk about the big three sort of in this space. And those are copyrights, trademarks, and patents. We'll go in that order. So let's jump in. And by the way, we have a small enough group here where I think, we can do questions kind of as we go. In particular, I'll pause for questions at the end of each section here, so that we can, before we move off of copyrights and into trademarks or patents or whatever, we can chat about any questions people have. We should have plenty of time for that. So, what is intellectual property? It's mostly in these four categories you see here. So, patents are kind of a classic one, right? That's inventions. That's about devices and processes and new compositions and things like drugs or, chemicals, but also obviously things like machines and electrical circuits and this kind of stuff. Patents, as we'll see, that's for things which are new, which have never been done before. It's about novelty when we think about patents. That can give a business broad protection over its ideas. Patents are pretty complicated, pretty expensive to obtain, but they can be a cornerstone piece of intellectual property for a business. Trademarks, next on the list. So now we're talking about brands. So it's words, slogans, logos, right? The little circle R. By the way, the little circle R means it's a registered trademark, as we'll see. We can talk about what that means and what that is. The little TM means it's not yet registered. It just means that whoever's using it thinks that's their brand, but they haven't gotten the trademark office to agree with them yet. So trademarks are about an indication of goods, of the source of goods and services. So, like I said, this is a branding question. This is about protecting the goodwill associated with, your business's good name out there in the marketplace. Copyrights. Most people are familiar with the idea of, a copyright and what it is. It's works of authorship, right? It's the proverbial pen to paper to create a book, to make a drawing, to make a painting, but it's also things, in our modern time, which is a little bit, more ethereal, I guess you might say. So software, computer code, right? Music is sort of maybe one of the original where it can be recorded and put onto some sort of medium and distributed. That's subject to copyright. So, we still have the pen and the paper analogs, but these are things which are more digital in nature. And the last one, which we're not going to talk about in great detail here, but I will mention it because it's important for some, is trade secrets. So trade secrets are a little bit like patents in terms of the sort of stuff they usually cover. It's, sort of interesting or novel processes, methods. It can also be things like business information. So it's kind of the how-to, um, or the particular processes that a business might use to produce something, to manufacture something. The key thing to remember about trade secrets is that, unlike these others, which are subject to a registration and are part of the public record, trade secrets are kept permanently confidential. That's the whole point with trade secrets, is that they are kept under wraps. It's a secret. It's being maintained as a secret in a very deliberate way. And so it's not subject to any kind of registration or, government certificate of any kind. But it still can serve as a cause of action for a business that has its trade secrets misappropriated. The classic trade secret, is the formula for Coca-Cola, right? So maybe they could have gotten a patent on Coca-Cola back in the day. If they had done that, they would have been on the record about exactly how to make it. And 20 years after, as we'll see, that patent would have expired, and then Coca-Cola would be in the public, and anyone could make it with no no possibility um, of getting trouble at the hands of the Coca-Cola company. Instead, they made it a trade secret. The value there is that it's been a trade secret now for probably going on 100 years. It's never going to expire, and they keep it permanently confidential. So that formula is and will remain a trade secret for as long as they keep it a secret. So let's think about, there's a couple ways to sort of think about intellectual property. First of all, I'll just say that when we say those words, intellectual property, well, what is that, right? It actually is property. It's a thing which can be owned. It can be transferred to another person or business. It can be used as security for a loan. If the business gets sold, usually the intellectual property gets sold with the business. So it's property. So there's a couple ways to think about this. One is as your IP. So it's the intellectual property that you are developing as you go about the business of your business. So you can obtain registrations for your IP, as we'll see, and that can enhance the value of your business. Like I said, if the business gets sold, the IP goes with it. That's one of the assets. So, these can also be used the way other kinds of assets, capital goods and equipment and other things in real estate, right? Those are all assets too, and they can all be used in similar ways, right? They can be used as a thing which creates value within your business. They can be used as leverage for, financial purposes. In the case of intellectual property, they can be licensed. So you can give selective permissions to others to use your property, to borrow it essentially, under some terms that you've created. And they are a tool or a weapon that you can use to go after copycats. So if somebody makes an unauthorized copy and infringes your intellectual property, then you have a cause of action, a course of redress against that copycat. I will say too that when we think about intellectual property infringement actions, that's a courts thing. It's not a police thing, right? So what do we get when we have intellectual property and there's a copycat out there infringing it? We get access to the courts, and we can ask a judge, sometimes a jury, to recognize that the infringement has occurred and that there are damages as a result, and then try to get a civil judgment against the infringer where we essentially get to take their money, right? This is what civil, or get them to do something specific. This is what civil judgments are all about. This is not a criminal thing. We don't get access to police. We can't call up the local sheriff and say, my neighbor's infringing my patent, go get him, right? We get the courts only. So we can think about it as a thing that our business or that we own, but then we can also consider the risk of other people's IP. So we can be thinking about how are we going to stay out of trouble? What are we going to do to have security against the unforeseen trouble or expense which might come if we even unintentionally infringe somebody else's intellectual property? So there's this due diligence piece, right? Where we can think about, oh, like I'm going to do something that's kind of similar to my competitor. Maybe that's going to cause a problem. I should probably figure out what kinds of IP they might have because I kind of want to copy them. Am I allowed to do that or am I not allowed to do that? That's the due diligence piece, thinking about their IP, what does it cover, what rights might they have against you. So when we do this, we can gain confidence that, hey, we're about to invest in this new product, this new service, and we're going to build a sort of infrastructure within our business around this idea, but we want to make sure that we're not going to run into trouble and end up having to shut the whole thing down as a result of having made this investment. So the due diligence piece is another part of this. And, by the way, there is this idea of being the accidental copycat. So sometimes we just don't know that there was somebody else's IP and we land in trouble purely by accident. That can happen. Now, the penalties for accidental infringement of IP are lower as a rule than doing it intentionally, but they still exist. And so sometimes we want to do a little due diligence on the front end just to make sure that we're sort of in a white space and not going to step on somebody's toes and end up in trouble because of it. Okay, so let's get into the details on some of this. We'll start with copyright. And I start with copyright because it's a thing that most businesses have. Almost everybody who's creating something, who has made a business, who owns a business, has some copyrights to their name. So what is a copyright? It covers the expression of an idea. So it's the expression. It's not the idea itself. In the Harry Potter books, there was a copyright issue where someone had written a book that had a lot of similarities. It had some similar characters who had similar names and similar themes. But that wasn't, it was kind of a closed case, but in that case, it wasn't a situation where they could go after the creator of the Harry Potter books because the expressions were different. And just the idea of this sort of fantastical world that Harry Potter, inhabits, that's not covered by the copyright. It's the expression. It's the actual words on the page in the book. And we're going to talk about sort of, this is a fuzzy line, but just know that, basic ideas are not protectable. It's all about the expression. So, for example, right, computer code, when we think about businesses particularly, that express some sort of business technique, that can be copyrightable, but the underlying data and correlations you use to get there, not copyrightable. So for example, right, think about this dashboard. So we might go out and collect a lot of data and information, and we've really worked hard to get this stuff and collate it and make sense of it and make the data analyzable and consistent enough where we can actually use it to gain insights. All right, that's a lot of effort. That's a lot of diligence. That doesn't create a strong copyright case. Because diligence and effort, the sweat of the brow as it's called in the law, that's not enough to create copyrights. Instead, it's all about the expression. So when we then take that data and we express those insights that we've gotten from it in like a dashboard or an instructional where you sort of see the graph or you see the bar chart or you see the pie chart or something and you say, ah, I see, I understand. Isn't that interesting? Now that expression, that's copyrightable. So someone else could develop the same data and not have any trouble with the other person's copyright. But if they then start creating a dashboard just like yours, that can create trouble for copyright. Okay, so about that trouble, how does one end up in trouble for copyright infringement? So there's kind of two pieces to this. One is how much did you copy, right? The extent of the copying. But then the other one is what can we say about your access to the copyrighted material? So there's sort of a sliding scale here, where if we think about, well, you copied most of the material. It's almost the same. It doesn't have to be identical for infringement to occur, but if it's pretty darn close, right? You took most of it. Then we're not going to worry about whether you were looking at the copyrighted work as you did this. We're not going to worry about access. On the other hand, if there's somewhat less copying, then we start to get interested in, well, were you doing this copying on the basis of the copyrighted work sitting in front of you? Did you have a lot of access, in other words? So getting back to the Harry Potter example, there was evidence in that case that J.K. Rowling lived in the place where the copyrighted earlier work was being distributed at the time. And so they were sort of trying to say, hey, she had access to our work. She would have been looking at it. She would have come across it because she was living in that area where that book was published and sort of in circulation in the eastern United States at the time. She was there. She had access. And so, therefore, the theory of the case is, hey, less copying is okay because we can show a lot of access. It didn't work in the end, but that's the way this plays out, right? In the end, they said, well, the copying still isn't enough. And by the way, we can't demonstrate definite access. We just know that she sort of was in the world at the same time as this book was on the shelves. So this gets into this fair use question. And a lot of people have heard of this fair use idea. It's largely misunderstood, but it does exist. It's a real thing. So fair use basically says, hey, some copying is okay. It can be okay. It's fair use. So how does this play out? Well, we only took a little bit of it, right? This is back to the extent of copying question. So a small portion of the original work. A classic example of this might be something like a walk-on song for you baseball fans out there, right? So you're at the baseball game, you're between batters, the new batter is coming up, and they play a snippet, maybe 5 seconds, 10 seconds, of some song that the batter has chosen that they want to hear on their way up to the plate. That's a tiny little bit of the full song, 5 seconds of it. Small portion, maybe fair use, right? Similarly, no diminishment of commercial value. So here we're saying, yeah, I took a little bit of your work, but I'm not competing with you. The walk-on song, right? I'm not out here publishing work. I'm not giving a performance of, your song for people who came to hear music. I'm just doing this walk-on thing. You're not, nobody was going to make any licensing fees from that anyway, right? So your original work's commercial value is sort of undiminished by this action. Used for other than commercial benefit, right? So, right, I'm not trying to make any money from my infringement. I'm not making any money from my infringement of your work. It's fair use. That's another example. I've created a predominantly new work. So an example of that, some people might be familiar with Andy Warhol's Campbell Soup painting, right? He took the copyrighted Campbell Soup label and made something completely new out of it. This commentary, right? A brand new work with a bunch of these labels all within the painting. That can be fair use. Used for education, right? So in my classes, I do PowerPoints and I've got little images and stuff, which by the way are all being taken from Creative Commons. We'll talk about that in a minute, or from some other licensed source. But used for education can be fair use. And critique, right? Back to Warhol's painting, or satire, right? So we're allowed to critique and satire. All fair use. Sounds great, right? When you think about this, you think, oh, good, well, fair use, that's pretty nice. I'm not going to worry so much about other people's copyrights. But the problem with that is that it's a fact-intensive analysis. It's not an insurance policy, at least not typically. Fair use is a defense to copyright infringement, and it doesn't mean that you can't be accused. So usually, the classical case of success vis-a-vis copyrights is to avoid being accused in the first place. Because the cost of defending someone else's copyright infringement lawsuit against you are, right? So it might be fair use in the end, but maybe it's a close question and you have to get a judge or a jury to weigh in on whether it really is fair use. Well, it's kind of a loss, even if you win in the end, because you were accused and you had to defend. So now it is possible to create fair use and use that as a strategy for going forward. Usually that involves opinions of counsel, right? Where you're going to go to your lawyer and say, hey, I have a baseball field. I'm doing single A baseball. I want to do walk-on songs. How much of these songs can I play, attorney? Please write me an opinion that says you're fine. It's fair use. Okay, fine. Now you've got an opinion of counsel in your pocket that you can bring out if somebody accuses you, and you've done the legal due diligence. In that case, you sort of are using fair use like an insurance policy, but that's sort of what's involved. The problem with fair use is that a lot of people say, it seems like fair use to me, I'm not going to worry about it. And then the copyright owner comes around and says, I don't think that's fair use, and I'm suing you, right? And this is not a good thing. So common misconceptions, right? I'm a nonprofit. I don't need to worry about it because we're not trying to make money from these copyrights. I'm a nonprofit, so I must be protected under fair use. Wrong, right? That's just not true. Nonprofits can and do get sued for copyright infringement. Or I'm just using this internally, right? I'm just doing employee trainings, and I'm not going to worry about copyright infringement on the materials I'm using for these trainings because it's internal, so who cares? Still infringement. Now maybe it means you're not going to get caught because no one will find out that you did it, but it's still infringement. You still could get caught, and if you do get caught, you're still in trouble. And the classic one, well, I just got it off the internet, right? I got a bunch of these images and I found them on the internet, and I just right click, hit save as, and I save it to my computer. It's freely there. What's the problem? That one can be a big problem. People grab the images, they put it up on their blog or up on their website, and then they get a cease and desist letter from one of these rather trollish companies that exist out there in the world for the purpose of suing people who did exactly that. And they ask for, sometimes usurious amounts of money. And the problem is you actually are in trouble. You grabbed a copyrighted image and then you put it up on your own website. That's copyright infringement, classic. Now the problem with the sort of copyright trolls, and the reason I call them that, is that they'll come back to you and say you owe us $10,000 for every image you took, and that is usually a ridiculous position. but it's trouble. And I've had a lot of clients over the years who've gotten into exactly this kind of trouble. And it's a problem. I mean, we still have, like I say, we still have to defend, we still have to respond. We don't want to be hauled into court because businesses have better things to do than to defend copyright infringement lawsuits. So how do we stay out of trouble here? There's various ways, some of which we've been talking about, but one of the big ones is looking for Creative Commons and open source. So Creative Commons are places where creators can put up their work and say, hey everyone, go ahead and use this, right? Stock image, I want you to use it. It will raise my profile. Sometimes they can reserve their rights in some needs or in some regards, right? Where they'll say, I want attribution. Okay, we'll give you attribution. Other than that, they're asking for no other compensation. So it eliminates the need for these individual negotiations, and it gives you sort of this clearinghouse of places where you can grab stock images. Open source is similar. This is more for like software type stuff, right? It's code and design documents, it's content, things like this. But again, these things can sort of be grabbed and used under the terms and conditions established and communicated by the creator. There's an MIT license in particular that is the most common. One thing I'll say about Creative Commons and open source, they both still sometimes do have terms and conditions attached. Often it's just, I want you to do attribution, right? So make it clear where this comes from. And as long as you do that, you're in compliance and you have no copyright issues. Or it can be other things, right? So be aware of what the terms and conditions are. But these are sources of places where you're not going to pay money to get access to material. So in general, how do we think about this? Who owns this thing? So the default is that the creator of the work owns the copyright. That means that it automatically attaches to the person who put that pen to paper. It also does this automatically. So aside from a copyright registration, which can be a good idea, and we can talk about why if anyone's interested, but registration or no, copyright automatically exists as the result of the person creating the creative expression that is subject to copyright. And the one who owns that is the creator. So how does someone else come to own a copyright? Two main ways. One is a work for hire. That's where someone is the commissioner and they're saying, creator, please make me something. I want you, my graphic designer, for example, to make some creative expressions on my behalf. And it's going to be for my business. So that would be a work for hire. And in that situation, the owner is the commissioner and not the creator by default. But a thing to remember about work for hire is there needs to be an agreement at the time that the work is commissioned and created that says this is a work for hire and I will own it. You, the creator, will not own it because I'm hiring you to do it. If there isn't a written agreement in place that says this is a work for hire, then it's not a work for hire. Even if you did actually hire the person and they did actually do it on your behalf. If there's no written contract that says it, it's not true. Need the written contract for it to be true. The other way is after the fact. We do it by assignment. So the creator owns the copyright by default, and then they can assign it to somebody else. That's another contract, right? An assignment agreement. This is commonly done. Well, sometimes it's done with the graphic designer and there was no work for hire agreement in the first place, so we come in and clean that up with an assignment. Or another thing to keep in mind is if you're a business owner, very often the business entity, the business that you own, that should be the owner of your copyright because that's the one benefiting from its use and the one who will be harmed by its infringement. So usually the business should own the copyright, but the business isn't the creator, the person is. So in order for the business to own it, the person will need to assign the copyright to the business. Okay, so, what do we do with all this? Well, just know that when you're thinking about content that you're going to distribute, consider who owns that. Consider how you got it. Where did it come from? If it is privately owned, then what is there a copyright out there and what does it cover? And are there terms attached? Is there something you need to be doing to make sure that you sort of um, uh, obey or comply with whatever terms there might be attached? Or, did you get it, in fact, from something other than Creative Commons? Did you, in fact, essentially steal that image and now you're about to publish it, um, and the owner may or may not come after you for that? Okay, so we're going to move on to trademarks in a minute. But before we do, are there any questions from the group on copyright? Or I haven't been looking at the chat, if there's anything in the chat.
Nothing in the chat as of right now.
Okay. Does anyone have any other questions? You feel free to come off mute or type into the chat or whatever if anyone has questions about copyright. Otherwise, before we move on to trademark.
Yeah, hi, this is Heidi. Thank you so much for all of this information. Um, with regard to sort of the copyright infringements and things like that, I'm just curious how common that is. I mean, I would never intentionally steal somebody else's property. Uh, and there are so many ideas. And I heard you say the distinction between ideas and expressions, but I feel like that's probably can be a really blurry line. And I'm an artist and in creative worlds and have a lot of people where we just sort of intend to get together to think out loud as partners almost. So, yeah, maybe if you could speak to the commonality of that or
Mm-hmm.
I just don't want to spend so much time dotting I's and crossing T's to protect myself to be fearful, but I also want to be wise, I guess.
Yeah, yeah, I hear you. So the trouble spots for people who, are just doing their best out there in the world are usually unintentional taking of something and using it for your own purposes, your own commercial purposes, not realizing that the thing you took is somebody else's work. And like I said, what actually happens, and by far the most common situation is a photograph taken off the internet, right, and used on your own website. There's a cottage industry of people who go around and make trouble for people who did exactly that. And like that's a tough situation because and that, by the way, that thing is quite common. I don't know, it's hard to know exactly how common actually, which is one of the problems. But pretty reliable sources are suggesting that like there's one law firm in particular, I'll avoid naming them, although I'm tempted to, who's probably sent 100,000 cease and desist letters within the last handful of years. And I personally know at least like 5 Vermont companies who've come to me with these exact things going on. So that's really common. A lot less common is something where someone says, hey, that looks sort of like the thing that I did, and I'm going to now make trouble for you because I think there's commonality. Right? Usually that kind of trouble comes as a result of the thing being very successful, right? That's the J.K. Rowling Harry Potter example, where she writes the books, they're super duper popular, she becomes fabulously wealthy, and somebody comes out of the woodwork and says, you know, I wrote a book 10 years before and it had a bunch of similarities and I'm going to sue you for copyright infringement. That person still lost, right? They didn't win that lawsuit, but they did make trouble. It was only worth it for them to make trouble because the books had already become so iconic, right? So that we see that, but like that's a very nice problem to have, right? Like I created a work that's a global, phenomenon, and therefore some people are going to try to make trouble for me. Give me that problem. That's a nice problem. But in general, I think where to get your hackles up and to be thinking about this a little more rigorously is if you're going to sort of base your work on someone else's work and you sort of feel like, I don't know, how far afield do I need to go before I'm safe? If I were Andy Warhol making the Campbell Soup painting, well, okay, maybe then I would say, not a bad idea to go talk to a lawyer and say, like, am I on safe territory here or not? Right? Because I'm going to copy this thing, right? I'm going to take this thing from the Campbell Soup Company, who may be litigious and certainly has access to lawyers and the legal process, and I'm going to use it for my own commercial purposes. Now, I would say that's fair use, and I don't think Andy Warhol ever had any trouble. But in a scenario like that, I think it might be worth it. Otherwise, I wouldn't worry too much about it. Does that make sense?
Yeah, thank you so much for just elaborating a little further. I don't want to
Sure.
be scared, but also technology, AI, all that stuff is uh, a new world. So,
Yeah, for sure. Yeah, we might talk a little bit about AI if there's time at the end. AI and copyright is pretty interesting. First of all, the AI companies have, in fact, hoovered up all a ton of copyrighted information. They are right now being sued by the New York Times and a consortium of other news organizations who have huge, huge libraries of copyrighted material, all of which has been used without license by the AI companies. And now the AIs can create their own works, which can't be copyrighted, by the way, because remember, the copyright attaches to the author. An author, in the meaning of the law for our purposes, that's a human, and an AI is not a human, so an AI cannot create copyrighted works. But yeah, we still worry about this, right? Because AI can create a new image, which we then might use, but we don't know sort of the provenance of that image. But we do know that the AI was trained on other people's copyrighted stuff. And so, there can be issues that show up there. Any other questions before we move on to trademarks? We can always revisit copyrights at the end too if something comes up. All right, hearing none. Trademarks. Okay, so what's a trademark? We talked a little bit about this at the beginning, right? It's words, it's names, it's symbols, devices, or some combination of those things that's used to identify and distinguish goods and services from others. It indicates the source. It's all about indication of the source of the goods and services. So it's slogans, taglines, catchphrases, right? Iconic trademarks shown below. Coca-Cola, Ford, right? Just Do It, Nike, Advil. Those are all trademarks. So when you see a can of, fizzy sweet liquid and it bears that Coca-Cola swoopy letters on it, you know something about the product that's in there, but more importantly, you know who made it. Coca-Cola made it. That company, not a different company, Coca-Cola, right? If you go and buy a car and it's got the blue oval and says Ford, you know where it came from. It came from the company that makes Fords, right? Ford Motor Incorporated. It didn't come from Chevy, and it didn't come from somebody else, and it didn't come from some guy in his garage making Ford-like products and calling them Ford. If somebody is doing that, then that's trademark infringement, and you better believe the Ford Motor Company is going to shut it down. And they're going to be on very solid legal ground when they do so. So it's about indicating the source. I think an important thing to remember and an important frame to consider when we think about trademarks. You know, as with other kinds of intellectual property, we consider that they're protecting the creator, they're protecting the business. And they do that. But in the case of trademarks, they're also protecting the consumer. And that is actually the primary rationale for the trademark system. So if I'm a consumer and I go to a used car lot, and I've always had Fords and I really like Fords and they've always been really good cars for me, and I just think Fords are the best, right? And I don't want anything but a Ford. And I go to a used car lot and I find all the ones that have the blue oval with the Ford on the front, and I pick one of those. As the consumer, I'm being protected because I know that when I saw the blue oval with the F-O-R-D inside, I know who made it. And someone else didn't make it. It's not a knockoff, right? It's the real article, the genuine article. I'm getting a thing that was made by the company that uses that trademark. So I get to short circuit my own decision making, and just find the mark that I trust and that I have goodwill associated with that. And I use it, right? Nike shoes, like, oh, Nike shoes, they fit my feet the best. I've tried the Sauconys and I've tried the Adidas, and they're just not as good. Nike, that's the one for me. I find shoes that have the Nike with the swoop. I know where they came from. They're going to fit me just like the other ones fit me. And if someone else creates a shoe and uses Nike, but it's not coming from Nike, then they're infringing a trademark and they're going to be shut down. That protects me because I don't want to get a knockoff. I want to get the real thing, right? Protects the consumer. All right, so how does one get a trademark? What counts as a trademark? That's where the spectrum of distinctiveness comes in. So at the generic side of the spectrum, you may not have a trademark. On the arbitrary and fanciful side of the spectrum, it's inherently registrable as a trademark. And descriptive and suggestive are sort of in the middle. So what do we mean by all that? So generic trademarks, not registrable, that's common names. So you can't get a trademark for gym bag brand gym bags. And you can't get a trademark for Apple brand apples. Nobody gets to lock down the word apple in connection with fruit, particularly apples, right? Or probably any other kind of fruit. So, because it's generic, right? So we're not going to prevent people from using words that describe the thing by giving someone else a trademark for that purpose. Next up the line, descriptive. Now it's getting a little less clear. So this describes the quality, a characteristic, feature, ingredient, something about the associated product or service. These are hard to trademark. Not impossible, but to get a trademark to something which is descriptive, you have to show distinctiveness or secondary meaning. As a practical matter, that means you need to show that you have already built the brand large enough that people know your trademark and already associate it with your goods and services. And how do you do that? Like surveys, right? Polls. It's not easy to show secondary meaning, but it can be done, right? Rugged outdoor products, right? That's descriptive, right? It's like, yeah, you want your outdoor products to be rugged because you're going to use them outside, right? So they need to be rugged. How do you get rugged as a trademark? That's not generic. It's not just telling you what the product is, but it is descriptive. To get that kind of trademark, you'll need to show secondary meaning. Not easy, Tough row to hoe there. Go up the list, though, into suggestive. Now you're into registrable territory. So now instead of describing a quality or characteristic, we're only suggesting it. So you need some additional perception to reach a conclusion about what that thing means. So it's inherently distinctive and it's registration eligible. No evidence of secondary meaning. Copper tone suntan lotion is sort of a classic, example of this, right? So it doesn't tell you anything really. It's not describing what the suntan lotion is or does, but there's a suggestion here, right? Oh, yeah, if you put the stuff on your skin and you go out in the sun, you end up with a copper tone, right? Okay, fine. That's suggestive. It's not descriptive. That's a trademark. It's registrable. And then arbitrary and fanciful, right? These are the easiest trademarks to get and maintain. So arbitrary is a common word, but an unfamiliar way. Back to Apple, right? Apple brand apples cannot have it. Apple brand computers, arbitrary. Strong mark, easy to get, right? Fanciful is a brand new term. No one ever, it's a new word. It was coined. It has no dictionary meaning. Xerox, copier, Prozac for drugs. All the drugs, right? Like all the X's and Y's and J's and Z's, all the high value Scrabble letters that show up in drug names. Um, at this point, that's sort of like a cultural thing in the industry, but it started out, at least in part, as a way of ensuring that you were going to be able to get broad trademark protection because you coined a word, and no one's going to come out of the woodwork and say, "Hey, wait a minute, that was my brand first," because it can't be, right? It's a brand new word. Okay, so why do we do this? What does it mean if we have a trademark? It protects the brand. We talked about protecting consumers. It protects the brand by discouraging other businesses from adopting any kind of a name or logo or whatever, and this is the key thing, that's confusingly similar to the existing trademark. So when you have a trademark, it's it covers the exact usage in connection with your exact goods or services, but also a little more than that. Because the standard is it confusingly similar to, or, someone who's allegedly infringing? So if we think about, how that plays out in practice, it's a fuzzy standard, which is sometimes good for trademark owners um, because it can give you some protection beyond what your trademark has. But at the end of the day, we're sort of putting our mind into the minds of the consumer that we're trying to protect and saying, are they going to be confused if they see, the generic, we had Advil up there on the first slide, right? And it's the blue label with the yellow letters. If they see the generic stuff and it's a different name, but it's still the blue label with the yellow letters and it looks very similar, like on first glance, are they going to be confused? Is there a this is another legal term, is there a likelihood of confusion that they're going to reach for that thinking it's from Advil when it actually isn't? And if there is a likelihood of confusion, then there's trademark infringement, and you can pull that product off the shelf and make them change their label, right? So that's this confusingly similar standard. So usually we would do this for public-facing stuff, obviously, right? It's about commercial identity and brand. Usually we're not going to worry about trademarks for internal marketing and stuff like this, right? Because there's no consumers out there interfacing with that stuff. All right, we're going to get into patents, but let's pause. Questions on trademarks from the gallery. Simeon, you got a question?
Hi, Brian. Well, actually, no, a couple of questions came in while you were speaking,
Oh, great.
Janet, so I'm just going to read them to you.
Yeah.
There are two here. The first one is, what role does a signature on a painting play with regard to copyright?
Oh, interesting. So, I mean, that tells you something about the initial owner of the copyright, right? Because it's telling you who the creator is. And as we know, copyrights attach to the creator before they can go anywhere else. So unless it's a work for hire, but even then it attaches to the creator and then is automatically sort of transferred to the commissioner of the work. So I think that's what it's telling us is um, who owns it first and foremost. In addition, it's telling us something about the provenance of that work. And so if we think about a knockoff, then that's a key piece of a knockoff, right? So if you are making a direct copy, if you're going to be high on the copying side of the copying versus access, you're even going to include that signature. That's a direct copy, and that's going to be an open and shut case of copyright infringement. And by the way, there might be a trademark issue there too, because the um, the signature of the author acts as a source identifier. You know where it came from. It's indicating the source of, in this case, the goods, the painting. And so there's probably trademark rights in that signature too. So there could be a trademark issue there as well.
On that same topic of trademarks, she also asks, can the title of a painting be trademarked?
Only to the extent that the title would be used as a source identifier, which isn't usually what we think of when we think about titles, right? Um, so I'm trying to think of an example, you know, the Mona Lisa or something, right? Like, could someone else create a painting and call it the Mona Lisa? Probably yes, right? Um, because and the painting's different. There's probably no copyright issue there. There's probably no trademark issue there either. Because the Mona Lisa isn't a brand. It's not telling you where the painting comes from or who's the purveyor of that thing. Whereas Coca-Cola is a brand, right? That's telling you where it comes from. So it's all about this indication of source. And I don't see titles as typically operating in that way.
Janet, if you have further questions or would like to follow up with Brian with any of these questions or topics on this front, feel free to unmute and communicate directly.
Okay, thank you.
Yeah.
Um, I asked this because I've done a painting that's become well known and the name has become recognizable. So I just wondered about the trademark issue.
Yeah. I mean, it can definitely be the case that a title or a name can be a trademark. Actually, I was just thinking of our Harry Potter example, right? Harry Potter, I think, is the title of the first book at least. Well, I think it's of all of them, and then they have subtitles. That turns into a brand, and I would venture to guess that Harry Potter is a registered trademark at this point. It's used to identify the source of all kinds of other goods too, right? So if you get like action figures or T-shirts or other kinds of goods that are connected with that series of books, like you can't call something Harry Potter and pass it off as being related to the books unless you're allowed to do that, right? Now, if I wanted to make Harry Potter brand, weight loss drugs, maybe I could get away with it. Maybe not. I don't know. But, the goods matters too. So yeah, I mean, a title can definitely be um, a brand, but it has to be used like that, right? The way Harry Potter is definitely a brand, as well as the title of a series of books.
Okay, now thank you, Brian.
Sure.
Answer me.
Any other questions on the topic of trademarks from other folks? All right, we will assume not, and I'll turn it back
Okay.
over to you, Brian. Thank you.
Yep. And we can always come back to trademarks if people are interested. So let's start with a little poll. Does anyone in the room think they have or need a patentable invention? You can raise your digital hand. You can put something in the chat. I ask this because patents are, as I said earlier, a cornerstone for some kinds of businesses. But for the rest of us, they are of academic interest mostly. So if anyone thinks, oh yeah, I've got a patentable invention, or I'd like to have one, or I intend to have one, then let me know that. And okay, I see we've got one in there. Something to patent, concern about the expense. Totally. Yep, that's a thing. So let's talk about it. What is a patent, first of all? So patents are a negative right. What do we mean by that? They give the owner of the patent a right to exclude others from doing stuff. Exclude others from doing what? From making the invention, as a shorthand. What's the invention? It's the thing you claim in the patent. It's a little circular, but we'll get there. It's not just making it. It's also using it, offering it for sale, selling it in fact, or importing it. You can't do any of that with an invention that's under a currently enforceable patent. These things are temporary. They last for 20 years from the original filing date. As a practical matter, that means they give you about maybe 17-ish years of enforceable term because it takes a few years from your initial filing until your patent is granted, if it's granted at all. And that's not necessarily easy to do. What patents don't give the owner? Any affirmative right of any kind, basically. So they don't give you the right to make it, to practice the claim invention. Although you can't be excluded by others from doing it if you're the owner of the patent. They don't give you regulatory approval. They don't give you affirmative permission of any kind. They don't, and they don't give you access, as we talked about with respect to other kinds of intellectual property, they don't give you access to government enforcement mechanisms other than the courts, and in the case of patents, certain import authorities as well. And actually, that could be true for copyrights and trademarks too, right? The proverbial sort of infringing goods coming from overseas can be seized, right, by import authorities as a container full of infringing goods. You know, hey, import authorities, you may not, please don't let that into the country. Those are all infringing goods, right? That's all knockoff products. You can stop the importation. So how do you get a patent? What do you need to show the patent office before it will grant you a patent? And there are these people called patent examiners, and they sit around all day looking at people's patent applications and deciding yes or no, I'm going to give you that patent or I'm not going to give it to you. And it's sort of a quasi-adversarial proceeding where the examiner is trying not to issue any patents which would not be valid. And the applicant is asking for the broadest possible protection over their invention. So where are the points of contention here? Primarily two things. One is novelty, and the other is non-obviousness, which we'll talk about. Novelty means that it's something which has not ever been known to the public before the filing date of the patent application. It's new. It's never been done before in the history of humanity, right? Or the world. So novelty is actually the easier of the two standards to meet because you basically just have to say, yeah, no one ever made it. Not quite like this. If someone did, then a single what we call prior art reference could be used to show a lack of novelty. So we pick up a prior art reference. What's that? It can be an earlier patent or patent application. It could be a scientific white paper. It could be a YouTube recording where someone says, look at this thing that I made. It has all these details. And you say, oh, well, son of a gun. Those are all exactly the same details of my invention. It's what do you know? Every one of them is shown there in that YouTube video or that earlier prior art reference. Well, then I lack novelty and I can't get a patent. Okay, so let's say you're novel. No one has done quite what you've done. You still have to be not obvious. This is sort of inventiveness, right? How far above and beyond the state of the art have we gone with this new thing that we've made? And so this is a tough one, can be a tough one to meet, and a lot of patent attorneys, such as myself and others, spend a lot of time arguing with patent examiners over what is and isn't obvious. So, as a practical matter, what happens is the examiner will pick up a single reference that starts with the basics of what your invention has, but lacks a few details, and then picks up a second or maybe a third and fourth reference, combines them together and says, well, if you take all these and combine them, I can find all the elements of your invention. And I think it would be obvious to do that, right? I'm going to go out and find all of these references. They've all sort of individually got pieces and parts of your invention, and I think it would be obvious to just sort of put all that together and smash them together, and I'm going to call it obvious. And then you have to argue, no, you can't do that, and there are various ways to do that. So novelty and non-obviousness also has to be patentable subject matter in the first place. What does that mean? It means it's a process, a machine, some article of manufacture. It can be a composition of matter like chemicals and chemistry, or some improvement on those things. What it isn't, it's not living beings as long as they're natural living beings. So there's like the Harvard oncomouse. They created a special mouse just for the purpose of studying cancer. That actually was patented. But that's not a natural living being. Not naturally occurring substances. So interesting history of aspirin, the drug. It comes from tree bark. It's been known for millennia by native peoples of the world that you can chew on tree bark and it helps your pain go away. That's the naturally occurring substance. Can't get a patent on the tree bark. You can, and they did back in the day, get a patent on the distilled substance of aspirin, so they found this tree bark and they said, all right, there's something in here that's special. They figured out what it was. They figured out how to synthesize it and turn it into a little pill form that's potent and really does the job. That's patentable. That's not a naturally occurring substance anymore. No scientific principles, right? So, laws of nature are similar, abstract ideas, right? E equals mc squared and other things of this nature. We're not patenting that. It's stuff and its processes. So let's say you've got your idea, you want to get a patent, you think it's novel, and you think it's probably not obvious as well, and it's for a sort of classic thing or process. So you've cleared all those hurdles. When do you file for a patent application? Let me pause and back up real quick and just say that when we think about the other two major forms of intellectual property, copyrights and trademarks, those can wait. So when do you file for a copyright registration or a trademark registration? There are good reasons to file for those. Mostly that if somebody does copy your trademark or your copyright and you have a registration in place, then you're going to have much larger damages you can bring to bear against them. So your case against the infringer is much, much stronger if you have your filing in place. But the rights exist whether or not you have your filing in place. So we've talked about how copyright is created when you put pen to paper. just happens automatically. And trademarks, we didn't talk about this, but trademarks are created by the virtue of you building the brand. Right? Trademark rights at common law can exist without a registration. Patents aren't like this. With patents, if you don't file early, then you lose your rights. So when do you file? Ideally, you can file before you've disclosed the invention to anyone. So Jan, your son is asking about patents. This is if there's one thing you want to take away and tell your son or anybody else about patents, tell them this. Once you've disclosed your invention, your patent rights are being impaired automatically. So a patent should be filed before any non-confidential disclosure of the invention to someone else. If you do that, you've preserved your ability to get a patent, at least potentially, worldwide. But in the United States and a couple of other countries, and not most, by the way, just a few, you get a 1-year grace period where, let's say you've made a disclosure to somebody else, and it was not confidential, and it talks about the invention. So you did the thing that I've just told you not to do. You've already done it. You didn't know. Okay, you get a 1-year grace period in the United States during which you can file for your patent rights, your patent application. So you make the public disclosure, that starts the clock ticking. When the clock strikes 1 year, got to have that patent application on file. If it's not on file, then that invention has been dedicated to the public forever. It becomes part of the prior art that we were just talking about, including against the inventor themselves, right? So that works for the United States. It works for Canada. It works for Australia. It doesn't work for most other countries. Doesn't work for China. It doesn't work for Europe. It doesn't work for Japan. So the novelty standard includes this early filing. So a thing to remember, what's a non-confidential disclosure? Well, that's a disclosure to somebody who's not under a duty of confidentiality. How do we show that somebody's under a duty of confidentiality? Usually we do that with a non-disclosure agreement, right? The proverbial NDA. Having an NDA in place means that it was a confidential disclosure. If it's confidential, then it doesn't impair patent rights like this. Unless the person who you've disclosed to goes out and discloses it to somebody else. And then they would have breached their agreement under the non-disclosure agreement that you've made with them, but they still made a disclosure and it can still impair your patent rights. Also the question of what's the invention, right? Did I tell them the details, the relevant details that constitute my invention? If I did, that's the invention. If I just said, hey, I've got something really special, it's going to give you these great results and you're going to love it, but you didn't actually say how you do that, right? Then maybe you didn't disclose the invention. And so then this clock is not ticking. So there are contours around this, but this is something that trips up a lot of new inventors, where they go out and they start shopping the invention around and they kind of work on it. Maybe it gets mothballed for a little while. They sort of come back to it, and what do you know, after they come to me and they say, so 4 years ago I created this thing, and 3 years ago I gave a talk about it, trying to get some market traction, and then it didn't, but now it is getting market traction. It's time to file my patent. Sorry, too late. The 1-year grace period is over. Didn't file in time. All right, we've got plenty of time. I'm probably going to switch into a little bit on AI and how it relates to all these concepts we've been talking about. But before we get into that, questions on patents? Oh, well, Jan had a question about expense. Let's talk about expense in general. Patents are by far the most expensive thing to obtain of all the intellectual property rights. A typical patent application for a moderately complicated invention is going to be $6,000 to $8,000, maybe up to $10,000 to prepare. And then there's usually going to be some further negotiations with the patent examiner, and that can raise costs as well. Additionally, it's very hard to DIY a patent. It's just an inherently complicated system. It's not impossible to do it on your own. People do it. But there's a steep learning curve, and it's very tough to get it right the first time. But when the application is filed, it's pretty static. There's not a lot you can do to change what's in the application after you file it. So many traps for the unwary in the patent space. By comparison, copyrights are on the other end of the spectrum. Copyrights are pretty easy to DIY registrations. You go to copyright.gov. There are great instructions there. By the way, USPTO.gov, that's the US Patent and Trademark Office.gov. Also a great website. Tons of good information there. Very user-friendly. It's for the public. You know, these are government agencies. They're trying to decode this information for the public as best they can, and they're trying to make it as easy as possible to sort of DIY your IP filings. So copyrights are pretty easy. Copyrights are sort of who owns it, who made it. You give them a specimen, you pay your fee. I think it's $65 right now. They sort of look things over. If they have questions about whatever, they'll ask you questions, but mostly it's you just go through the process, you register the copyright, and boom, you're done. Copyright is registered, and now you've got that sort of bigger hammer to bring down on future copycats. And we can talk about what that looks like. By the way, for anyone who might end up in trouble with any of these these copyright trolls out there, one of the big questions that comes up is, do you have a registered copyright? If they have a registered copyright, or if you're a business owner and you've got a copycat and you're trying to go after them, if you have a registered copyright, then you get access to a higher measure of damages. In other words, how much money are they going to owe you for the infringement? That's called statutory damages. Statutory damages are only available to folks who have a copyright registration, and they can be huge. It can be $30,000 per instance of infringement, and those instances can rack up, multiples. Now, almost nobody gets $30,000 per instance, but it's on the menu. If you don't have a copyright registration, then it's not going to happen. Right? There's no statutory damages. You're pretty much stuck with lost profits, which basically means, hey, you sold a copy of my thing. I would have sold it if you hadn't, and I would have made money. So you owe me the money that I would have made, which isn't much of a deterrent, right? It's like, oh, go ahead and try it. And if you fail, then you'll just have to pay me your profits. Not as much of a deterrent. Trademarks are in the middle, right? In terms of DIY-ability, trademarks are, let's go back to trademarks. Trademarks are pretty possible to DIY, but there are some traps. In particular, there's going to be a question about, is your trademark available to you, or is there somebody else who already has a trademark that's confusingly similar? This gets back to this sort of question at the beginning about whose IP are we talking about? So you're trying to get a trademark to enhance the value of your business. In the process of doing that, you're going to be asking the question, does somebody else already have a trademark that is confusingly similar to mine? And the trademark examiner will be asking this question too. So this question of due diligence versus getting your own IP, these are related, right? Because if you want to get your own trademark, then you need to show that you're not confusingly similar to somebody who's already been using that mark ahead of you. So copyright's easy, patents hard, trademarks in the middle. Um, Jen, is that enough information about expense, or is there anything particular you want to talk about there?
Yeah, that was fine. Thank you. I appreciate it.
Sure.
Brian, I just had a couple follow-up questions for you on this. Is it okay to ask you? Or you want me?
Totally. Yeah.
Okay. So, with the trademark information you just shared about the cost and the ease, how would you go about determining if it's similar to something that somebody already has? Would you do a search at the patent and trademark office? Would you do a search online search? How would you go about that practically?
Yeah. Yeah. Let me share some links in the chat here.
Sure.
So here is the trademark search tool at uspto.gov, which you very helpfully put in the chat already, Simeon.
Yeah.
That just takes you to a particular spot within that site where you can search for trademarks, federal trademarks, right? So for a quick shot across the bow, you've got a business, or you're thinking about creating a business or a brand,
Hmm.
right? So this can be relevant to your business name, which is usually for most people your original brand. But even if your business is mature, but you have new brandings you want to create that are just product lines, then you're looking at creating a new trademark. Every time you do this, you run the risk of bumping into somebody else's trademark. So when you're thinking about branding in the early stages, that due diligence piece is important. And you can go search the trademark system. It's very easy. It's very like I said, it's very user friendly. And at least find out, is there anybody right on top of the branding that I want? And so, there's going to be a question about, okay, let's say somebody else has exactly the trademark. They're using exactly the same name, but it's with different goods or services. Then that can still be white space for you, right? Because there's no likelihood of confusion between, Ford cars and Ford aspirin, right? Nobody's going to think, oh, like that aspirin must be from the maker of my car. Like, no, of course not, right? So it's this intersection. But remember, we're thinking about this likelihood of confusion. So if somebody's close, then we start to worry. And this is one of the things attorneys, do in this space, is try to identify white space, advise about risk, say, I don't know, I think you're probably okay, but there's a risk, and here's where the risk is, and I think it's modest, or low, or whatever. And similarly, is the examiner going to let you have it, which is a related inquiry. So, on the one hand, are you going to be able to register your brand as a trademark of your own? And on the other hand, is someone else out there going to try to make trouble for you just for using that branding?
Okay. Thank you. Um, Also, when it comes to copywriting, can you speak to you know, the possibility of copywriting one thing versus copywriting a collection?
Yeah, right. So there are collection copyrights. These are commonly used for like photographs, for example, right? Where you get, like the Associated Press does this, where they've got a bunch of folks out there who are creating works for hire, right? So all their staff photographers are out there recording the world in the form of various photographs. Every one of those photographs is subject to copyright. And I am virtually certain that the Associated Press has work for hire agreements with all of their staff photographers, so they end up the owner. So they want to register their photographs, but they don't want to pay $65 a pop, right? Because they've got thousands upon thousands of photographs. You can register a group right? So you can take a whole batch of photographs and register them as one thing. And then that gives you copyright registration for the entire batch. So that's what the group registration does. Similarly, you can end up with copyrights. Um, just the other day, I created a copyright registration for game instructions, right? Like a board game type of thing. And it's sort of a big page, and it's got a bunch of text, but it's also got some artwork, and it's also got a logo, right? All those things sort of show up there. All those things are subject to their own copyright protection. The text is amenable to a copyright. The artwork on there, that's amenable to a copyright. And the logo itself is amenable to copyright and trademark, by the way. That can all be put into one single copyright registration, and it does protect each of the individual works.
So as we have a few artists on here, so the artists could copyright, say, a group of their work, paintings or whatnot. Is that
Yep,
correct?
absolutely. And that way you're not having to pay for many, many, many registrations.
Hmm.
Another thing that I'll point out here too, and this is true especially for copyrights and trademarks, maybe somewhat, well, it's true for patents too. Businesses have to make choices, right, about what they're going to protect and where they're going to seek registrations. Businesses don't have unlimited money, alas, right? None of us do. So they can't just say, I want all the IP, right? I want to do registrations for everything. Some businesses do that, right? I mean, Nike has a registration for the word Nike. It has a registration for the stylized version of the word that's sort of tilted. It's got a registration for the swoosh. It's got a registration for the just do it period, right? It's got all that. Those are all separate registrations that they've done. Small businesses don't have that level of spend available on IP. It's fine to be judicious about it and to think about where am I going to put my dollars for creating IP registrations that protect my business? And so if we think about trademarks, for example, we're going to look at, the name of the business to the extent that that's used as a brand. Or we're going to look at our iconic sort of brands. And maybe we're going to leave the rest aside for now. You can go for that later. Same thing with copyrights, right? There might be one particular image that is by far more valuable than every other image that's been created by that artist. And we're going to get a dedicated registration to that image, right? And we're going to spend the money on that and not worry about the others. So that's fair game. And I mean even patents the same, right? I mean I've had lots. This is usually for larger businesses where they've got a portfolio of patents and they're trying to hold their competitors at bay by sort of having this armory, right? But even there, they have to make decisions about, I don't think it's worth it. I'm going to let that one slide. But this one over here, that's really a big innovation, and I'm going to spend and fight hard to protect it.
Thank you. Um, Jan had a couple of follow-up questions on this topic. I'll just read them to you. Her first question is, what about books you write? Do you copyright each book? And then she asks, I have a logo for my business. That is part of my recognized brand. Do I need to register that? And
Mm-hmm.
and maybe just the last question I was going to ask you maybe ties into this last one from Jan. That I noticed on the Vermont Secretary of State's website, you can register a trademark. So maybe talk about if you're able to talk about the difference between registering your trademark with the state versus with the U.S.
Yep.
government.
Yeah, that's a good point. So on the copyrights question, yeah, a book is subject to a copyright usually, right? Just, I mean, again, there can be multiple copyrights within an individual book. There's the text, and there's cover art, and so forth, right? So there might be more than one, but usually a book is subject to sort of one primary copyright which covers the text, right? And so that's the important piece. So with the Harry Potter books, I'm sure are all have their copyright. I would hope that I'm sure they do have their copyright registrations all set. And so if somebody then copyrights a big chunk or copies a big chunk of that book, and passes it off as their own and tries to make money off that, they're going to end up in trouble. And there's a copyright registration to enhance the damages you can allege based on that copying. On the logo side of things, that is a classic trademark situation, right? So it's names, it can be plain words or stylized words, and it can be logos. That's the Nike swoosh, right? That's a trademarkable logo. It is a trademark in fact, and that can be registered. To Simeon's point, when we talk about registrations, we've been talking about federal registrations, and that whole we'll just go there, right? This whole spectrum of distinctiveness and this analysis of is it generic or arbitrary or somewhere in the middle. The feds are going to do this. There are state-based registration systems, including one in Vermont, which is very easy to DIY. And it's sort of like a copyright registration where it's just going to the Vermont Secretary of State's website and saying, this is my brand. Here's a copy of it. Here's a copy of the logo, or here's what the word is, or whatever, and here's what it's connected to, and you just register it. And they don't really, they don't do an examination like you get at the federal level. And you don't get nationwide trademark rights, but you do end up with a trademark registration within the state of Vermont, which would cover competitors also within the state of Vermont who are either here doing business or are selling goods into the state. But it won't necessarily protect you against trademark infringers in South Dakota, right? Unless they're selling into Vermont. That's where the federal registration comes in handy.
This is Heidi. I have just, I think this is a quick question, and I apologize if you already covered it, but once you get a copyright registration, for example, is that a one-time fee, or is that something that every year you get the renewal reminder and continue to pay?
Yeah, that's a good question. So in the case of copyrights, it's a one-time deal, which is great. In the case of trademarks, they have to be renewed every 5 years. And with trademarks, this is something that I don't think I mentioned. Well, let me just answer your question first. So copyrights are a one-time fee. They are good for the life of the creator, plus I think it's now 90 years. Right, so they last a long time. And this sort of gets to Janet's question in the chat as well. Can a trademark or a copyright or any other piece of intellectual property be inherited? Yes, absolutely. They are pieces of property they can move with the states, right? Or they can be owned by a business and the business can pass to an inheritor or a successor, right? It's property. So just like any other property, real property, personal property, it can be inherited, it can be passed after death of the creator. And in fact, copyrights do exactly that, right? They're sort of specifically intended that way, where they're good for the entire life of the creator, and then another 90 years to inure to the benefit of the creator's, descendants or whoever they've designated as the recipients of their estate, right? So we're zigging and zagging a little bit, but that's okay. So when we think about copyrights, it's a one and done deal. Trademarks need to be renewed every 5 years. And something important to remember about trademarks, you can't squat on a trademark. You have to show use in commerce for a trademark to be valid and registrable in the first place. So you can't say, oh, I'm going to use this brand sometime in the future. And, I'll register my trademark and then maybe in the future I'll use it. Or if somebody else wants to use it, they'll have to pay me first. It doesn't work that way. You have to be using it in commerce or you can't get it in the first place. And if you cease using it in commerce during the time that you own the trademark, then you will lose rights, right? You can't continue to own a trademark that you aren't using. This goes back to baseball. For any baseball fans out there, you'll know that the professional teams periodically come out with their old uniforms, right? They have their old ball caps with their old stripy uniforms and all the stuff from way back in the day. And it seems like it's like a nostalgia thing. It's not just that though. They're preserving their trademarks by using them in commerce. That's one of the ways you do that, right? You want to preserve your old logo from your, your old ball caps or whatever, your from your baseball organization. You got to use it. If you don't use it in commerce, you can't keep it. So, so trademarks have to be renewed every 5 years, and one of the things you do is tell the trademark office, "Yep, I'm still using it in commerce," right? Um, Patents, by the way, also have to be renewed a few times during their 20-year life.
Great. Thank you, Brian. Appreciate that additional information. Jan, did Brian get to your question? Did you have any follow-up questions on what he said?
Uh, no, I mean, I'm just like curious because through my business, I'm writing two sets of books on lesson plans, and I'm trying to figure out if each one would have to be copyrighted, or can I do it as because it's kind of there's a flow to why there is kind of a two-part of it, um, and trying to figure out whether I can just copyright the two together.
Yeah, that's a good question, and whether that could be done as a group. I suspect it could, but I'm not sure. Yeah, it might be worth it to just do a separate registration for each. They're pretty cheap, right? Um, but that'd be a question to work through with an attorney based on what you're
Okay, thank
particularly
you.
trying to do. Yeah. What does trademark cost, right? We talked about that. And it's the same every 5 years. So yeah, so right, patents, I quoted what 6 to 10,000 is like not uncommon. So maybe you could find someone to do it cheaper, probably not a lot cheaper. Copyright's pretty easy. You could probably do it yourself, $65 fee. Trademarks are in the middle. The fee is $350. That's payable to the trademark office, the USPTO, US Patent and Trademark Office. And that's per class. So sometimes you have more than one class of goods and services. Sometimes you have both goods and services covered under the same mark, right? So, trying to think of an example of that. Let's see if any of these are all goods. But, you could have, well, right, like Harry Potter. If we think about that as a trademark, which I'm sure it is, that's goods, various kinds, right? It's books, but it's probably also action figures, and it's probably also certain kinds of services. Like if there's an online Harry Potter game, that's a service. It's not a good, it's a service, right? Where we're providing this game for you to play. So all those are going to be different classes. If I want to register the Harry Potter mark, I probably am registering it for books. That's a class, $350. I'm probably also going to register it for action figures. That's a different class, not books. That's another $350. And I'm going to register it for my online game platform, the service. That's another class, another $350. So I'm up to $1,050, right? Just in filing fees to get my trademark. And if I've got an attorney helping with that, I'm paying them too. So a simple trademark, single class with attorney help, 1 to 2,000, mostly depending on are we going to do due diligence on the front end or just take our chances. And so again, if I'm the Harry Potter creator, if I'm J.K. Rowling, and I'm at the beginning of this process, and I want to say, hey, can I use Harry Potter, or does somebody else have that name already? And they're going to go out and look for Harry Potter. Does somebody else already have that? Is there something similar? Is there a registered trademark for it? Or maybe somebody else is just using it already as a brand. And they're going to assess the risk. That's the due diligence piece. And then depending on how that comes out, they're going to say, yeah, all right, looks like white space, no problem with the registration. Let's go ahead, we'll file our trademark application and then go through the process. So yeah, a couple grand is not an unfair assumption to make if you're going to try to file for a trademark with professional help and with some due diligence on the front end. But at least 350, even if you DIY it and do only a single class, you got to pay the 350. And oh, do you have to pay that every 5 years? No. Once you get your trademark, you've already done all the due diligence, you've done your application. There is a fee associated with the renewal every 5 years, but it's smaller. I don't remember what it is. It's like 150 or something like that.
Thank you, Brian.
Yeah. Any other questions? I like questions. Hearing none, we can talk a little bit about, in case anyone's curious, about the sort of AI landscape, right? How does AI fit with all this? Most of us are pretty curious about what AI means in our lives. I don't know the answer to that, but I can tell you a thing or two about what AI means in the IP space. So it can be integrated into IP, but you have to be careful about how to do this. It creates risk because it can make it hard to follow the rules. AI can create infringements that you didn't intend. All of this is against the backdrop of changing rules. I talked about how the New York Times and various other media organizations are busy suing OpenAI and the other major platform providers because their models were all trained on others' IP. I think it's probably the case that the courts are not going to say that OpenAI owes the New York Times like $6 trillion because of their infringements. They could say that. They probably could. They're probably not going to, right? And so the actual IP laws are likely to change as a result of AI, rather than deciding that we're going to preserve IP laws just the way they were, and even if it's at the expense of this new technology we call AI, and we're going to shut the whole technology down to keep the IP system as it was. Not likely, right? So we can have some strategies about this. So how about patents? How does this work? We talked about public disclosures, right? Patents are barred in the US a year after a public disclosure. They're barred internationally right away after a public disclosure. So AI is probably going to create a lot of prior art because it's creating a lot of stuff. It's creating a lot of information. It's publishing huge amounts of just stuff, some of which is novel. Probably it's going to it's going to expand the group of pre-existing publications, i.e. the world of prior art, faster than it has expanded before. That could make it harder to get a patent. On the disclosure side, let's remember this about AI, and this is a good thing to remember about AI tools in general. Query: when you tell Claude about your invention, is that a public disclosure? Probably it is, right? Why? Because Claude is not under any duty of confidentiality to you. In fact, quite the opposite. Claude, by its very terms of service, is going to take the information you provide to it and use it as training for future answers to others. So be wary about giving information to Claude or ChatGPT or anybody else. That is not confidential, especially if it's not a paid service. If it is a paid service, then there might be confidentiality protections in the agreement. Right? So what about this? ChatGPT, make me an invention. Can ChatGPT be an inventor? No. Just like with copyrights, AIs are not human, therefore they cannot be inventors. However, AI-assisted human inventions, yeah, that could be a thing, probably, right? But the human contribution matters. And you can't claim what you didn't invent. So, if ChatGPT basically gave you some critical insight, and you're not the inventor of that, then there is no inventor of that. You might be able to claim some other details that you came up with, but that'd be a tough one. And we talked about this, right? ChatGPT comment on my invention, right? Remember, they're not under a duty of confidentiality, and they do not generally maintain confidence. And by the way, the AI systems are more and more embedded in the everyday software that you are using, right? So just beware of the public nature. Janet asks, does trademark protect against AI infringement? Yes. This is one of the problems you can run into. Let me see if looks like I accidentally stopped my share. Here we go. This is a problem you can run into where you have AI create some image that you want to use, and you put up the image. And you think, well, that can't be subject to copyright because AI created it, and I just learned that, and we'll talk about this in a minute, that AI can't be a creator of a copyright because it's not a human. Okay, fine, but that image might be full of trademarks, right? And if you then publish that image, the owner of the trademark can say, whoa, 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 that's my trademark. You can't have that up there. Right, to the extent that you're using that trademark and there's a likelihood of confusion, right? And we start to get into that thing again. So yeah, trademark rights can protect against AI infringement but who are we going to be going after? I mean, you could try to go after OpenAI. Chances are you're going to go after the one who created the image or who's hosting it on their website. On the copyright side of things, right? It can't be an author. We talked a little bit about that. It's been trained on the IP of humanity. So we talked about that. There are big questions here. Watch out for unintentional use of others' IP. We've been talking about that. So Jan says, if a stock image is used to create something new and different, to some degree, right, with an added tagline or whatever, can you use it? That's exactly what we're talking about here. So we get into the question of what's the level of copying? What's the level of access? If I've used AI to create something new, probably the access is low, but copying could still be pretty high, right? It's quite possible for AI to spit out an image that turns out to be basically a perfect copy of someone else's thing, and we won't know if that's true, right? So that could create an infringement risk, for sure. Even if it's a little new, a little different, right? We don't know. And that's part of the problem of AI having been trained on the IP of humanity in the first place. It's aware of everything else out there in the world, and it might find someone else's copyrighted image and say, this is exactly what you're looking for, and give it to you basically unaltered. And now you're thinking, well, it must be okay to use. Not necessarily, right? That's a classic sort of unintentional infringement situation. Okay, so then there's the question of stock images, right? Stock images are ones where the creator has said, it's basically like a Creative Commons type situation, where there are some stock images where the creator has said, I am releasing this free as to the world. No attribution, no anything else. It's a stock image, please use it, right? And so you could trace it back and say, we know who the creator was, and they gave it up. Or it's expired, right? Because more and more we've got expired copyrights now, where it's old enough. The creator died. It's been 100 years since the creator died, and it's free to use because it's entered the public domain. So there is a public domain. When we think of stock images, like that can also mean, for example, like Microsoft Word has a whole set of stock images. Those are tied, as I understand it, I haven't actually read the agreement, right? But we all have terms and conditions we agree when we use Microsoft Word. One of them relates to the stock images, undoubtedly. We probably end up with a license to use those images for as long as, I'm guessing, we have a license to use that software. We give up the software, probably give up the license to the images too, right? So stock images very often come with some sort of it's actually a licensed image is what it is, and there are some sorts of terms and conditions attached. So that's an issue. So before we run out of time, I'll give you these QR codes. So at the Vermont Law and Graduate School, particularly the Small Business Law Center, we do educational consults. This kind of stuff like I've been doing for you here today, but it's tailored, it's individual, so you can submit a form to us through this QR code and you can get 45 minutes with one of our professors and usually some of our students, and we can address and give you education on whatever thing is of interest to you. So you want to take a deep dive on, commercial leases, we can do that. You want to go deeper on patents, we can do that. Whatever it is, right? You just explain what your questions are, and we give you 45 minutes of dedicated sort of educational content based on what you're doing. We did have and Simeon and I were talking about this at the beginning. We did have and expect to have again in the future a program where we can connect you to an attorney for free legal help for up to 10 hours. That program is on pause at the moment pending receipt of new federal funding, which we do expect, or sources of other sources of funding, which we also expect. So that program is not currently underway, but we do expect to restart it in the future. If and when we do that, as a person who's already attended one of our educational programs here, you would be eligible to request the 10 hours of free legal help. So you can reach out to us, again, use the QR code or just find us. We're the Vermont Small Business Law Center online. And you can check in with us in a few weeks or months and say, hey, did you get that attorney thing started up again? I attended the CVOEO seminar and I'd really like to get connected. We hope that by this summer we'll be back up and running and can make those referrals. All right. If there's
Great.
any other questions, we got a few more minutes. Otherwise, I'll pass it back to you, Simeon.
Thank you so much, Brian. I was just putting in your website into the chat box for folks to have
Perfect.
access to. But Sophia is going to be sending out probably in a few days a link to this video as well as the recording of this class as well as the links that have been shared in the chat to make it easier for folks to access. So, Brian, I just want to say thank you so much for all of your time today and your flexibility bouncing around to different topics and questions. I really appreciate you sharing your time and your expertise in these matters. It's so helpful. And I always sing the praises of the Vermont Small Business Law Center. I encourage everyone that I work with to take advantage of those great services you offer. And I'm really pleased to hear that the funding it has been approved and you're just waiting on it. So that's really hopeful. So thank you for all that you do.
Absolutely. Yeah, you bet. And we're available to you now for those educational consults.
Right.
So you can always come to it. That we're still doing that. So you can definitely come to us for just more a deep dive on something in the educational context. But yeah, like I said, hopefully we can also make those referrals to attorneys soon.
Yes, and I've sat in on those educational sessions with folks too, and they're great. And I encourage everybody that I work with to attend and take advantage of those too and attend those sessions. So that's great. Thank you.
Yeah, you bet.
Great. Let's see, Sophia. Yep, Sophia, did you want to mention anything?
I just wanted to again thank Brian for his time and his knowledge, and Simeon you as well for getting to questions and also asking some great questions. I think they'll go off great in the recording. So thank you all for attending. Really, really appreciate your time.
And thank you, Sophia, for all of your work putting this together. I couldn't do it without you. Thank you for all the background help you do and spreading the word and getting the whole system set up so we can offer these. So thank you.
Thank you.